courts have routinely held the same thing. And essentially, the analogy goes like this. When you're in America and you're a foreign-born citizen and you're still an alien, not an American citizen, you're here as a guest. It is a privilege to be in the United States. And so the courts doctrinally distinguish First Amendment issues from deportation and national security interests. Government can't come in and punish an alien for having participated in a pro-Hamas protest. But when looking at security determinations over on this side, they can say, you have no actual right to be here. You're our guest. It's a privilege. And we're going to show you the door now. Hey guys, it's Ben Barr here. We're going to look at Mahmoud Khalil today. What does the First Amendment have to say about the executive, in this case Trump, using the power of deportation against a lawful resident alien who may also be engaging in some agitating speech, who may be linked with outside foreign forces that are hostile to the United States, that is, Hamas and pro-Palestinian forces. The case that we're dealing with is Khalil at Columbia University, a graduate student who seems to have played a significant role in many of the pro-Palestinian protests that arised after Palestine's attack on Israel. And the question then is whether use of the deportation process satisfies the rule of law or constitutional norms. Now, I can tell you this as a starting first principle. Supreme Court has routinely held that the First Amendment's guarantee of free speech is generally interpreted to protect all people within our borders. That includes non-citizens. But that's not as broad as you might think, because the court holds a doctrine that a non-citizen is allowed to speak and government cannot criminally punish them for that speech. So in this case, if Mr. Khalil engaged in this dangerous rhetoric and advocacy supporting Hamas, then it would be unconstitutional to punish him for that. But as we move on to other actions that the government might take, the court has taken a decidedly different stance. So since 1952, federal law has authorized denying entry or the deportation of any alien who endorses or espouses terrorist activity or persuades another to endorse or espouse terrorist activity or support of a terrorist organization. So even purely political advocacy, otherwise what we might think of as lawful speech, can trigger removal if it aligns with a designated terrorist group like Hamas. This is clear statutory authority, and whether that conflicts with the First Amendment is actually a fairly nuanced and contentious issue. Now, America has gone through several periods of fear of outsiders either influencing and destabilizing national cohesion or being an actual national security risk. So we can think of two Red Scares that America went through. Aftermath of World War I in the late 19-teens to early 1920s, there was a widespread fear of anarchists, socialists, and other radicals, many of whom were immigrants coming into America. And the government responded to these concerns by greatly expanding the grounds for deportation based on ideology. In fact, the Immigration Act of 1918 authorized deporting an alien who was an anarchist or who advocated overthrow of the government. And we have a famous historical reference for this in America, and that's the Palmer raids. The federal government came in and rounded up and expelled foreign-born dissidents. Emma Goldman, a Russian-born resident alien, and hundreds of others were deported under this act. The crime at issue there was urging resistance to the draft in advocacy of what would be considered foreign political ideology. Now, at this time in America's First Amendment jurisprudence, there was very little distinction that was made between advocacy and incitement if the speaker was an alien. And we covered this in some of the first videos I talked about national security and the First Amendment. You want to do a deeper dive on that case law, you can go there. But free speech rights at that time, in the late 19-teens, early 1920s, for foreigners was very little in the face of national concerns about security or about subversion. America also had a second Red Scare, and this was in the late 1940s and 50s. There's a fear of communism that led to another wave of policies that targeted political expression solely by aliens. There was an Immigration and Nationality Act in 1952 that made past or present membership in the Communist Party suspect and a deportable offense. So thousands of legal aliens were placed in proceedings for prior communist ties. And Justice Frankfurter, during some of the cases that examined the constitutional rules that oversee this, said, although it shocks our conscience, Congress and the executive actually enjoy a plenary power over immigration, and it allows them to deport an alien for beliefs or associations that might be constitutionally protected for a citizen. Now, I want to highlight for you two cases during the sort of second Red Scare. Bridges v. Wixon was in 1945, and it recognized that resident aliens were invested with constitutional rights. That involved a labor activist who was deported for alleged communist affiliation. Now, it was actually overturned due to a lack of fair procedure, so due process concerns saved the day at that point. And there's an interesting quote from that case from Justice Murphy where he says that once an alien lawfully enters and resides in the country, he becomes invested with the rights guaranteed by the Constitution, and that includes the First Amendment. But if we fast forward 7 years later to Harrisades v. Shaughnessy, 1952, in very much the Cold War climate, the court took a different view, and it upheld the deportation of longtime alien legal residents for past membership in the Communist Party. It found that it didn't violate the First Amendment. Essentially, Congress's and the executive branch's power to deport was held to permit deportation on political grounds, and if any First Amendment concerns would yield to the national security concerns by government. Now, we've talked about deference before, and you should probably know by now I'm not a fan of judicial deference. That's when judges sort of give government an upper hand in not having to put on as much evidence or support for their case. Deference is often the central part of any case involving national security, where we allow the executive to be able to trump other rights that we might see. And, I suppose as to deference, if there's any category where it might be most proper to use, perhaps national security is true. It goes to the very ability of our nation to exist. I'm still a fan for putting on a thorough case and having thorough evidence on both sides, and I think the federal government can probably win in many instances and be able to show real national security concerns. So when we dig into the second Red Scare, we can look at some interesting cases. Harry Bridges was a labor leader who was repeatedly accused of being connected to communists. He faced deportation attempts for years. And where the Supreme Court came down was that a non-citizen didn't have to commit any overt illegal act. Just being affiliated with what it thought of as a subversive organization was enough for expulsion. Now, in Bridges' case, again, we have due process coming up. Due process was what saved him there. But Congress did ultimately tweak the law to make it easier to deport what they thought of as dangerous people like him. During the McCarthy era, foreign artists and scholars, like Charlie Chaplin, for example, were denied U.S. entry due to alleged leftist sympathies. So this ideological vetting of aliens was a Red Scare policy that treated certain speech or beliefs as grounds for exclusion. Now, these don't get changed until the 1990s on the entry side of the legal equation. But interestingly, for expulsion, for being able to deport lawful resident aliens or even illegal aliens, the ground still stayed. So if you were part of a subversive group or a communist group, you could be asked to leave the country. And indeed, then as we move into more modern history, we get into the 9/11 era and America's concern over extremist Islamicism and jihad, we see more tweaking and changes to this. So after the September 11th, 2001 terrorist attacks in New York, America's attention shifted to Islamicist extremism. Congress and immigration authorities broadened the net for speech-related deportation offenses. The Patriot Act of 2001 added a significant amount of sweeping terrorism-related grounds for deporting or barring aliens entry into the country. So any sort of endorsing or espousing terrorist activity was a specific inadmissibility criterion, so that would allow the government to bar you from entering. It would also give you a basis to be removed from the country. Now, we saw some of this play out actually prior to 9/11 in the late 80s to early 90s. There was a case called the LA 8. It was 7 Palestinian students and a Kenyan who faced deportation for allegedly raising funds and running a magazine promoting pro-Palestinian causes. Now, this got stuck in court forever, but as the court repeatedly acknowledged in that case, look, all of the activities that were done by these aliens would have been perfectly constitutional and lawful if it had been done by citizens. That is, it would have been purely protected political speech. And the FBI had a direct statement on that too, who investigated this. If these individuals had been United States citizens, there would have been no basis for their arrest. So we're starting to see that throughout American history, we've had a very clear distinction between the sort of pool of rights that citizens enjoy for First Amendment speech, and I am a full-fledged First Amendment fanatic. That's what I do for my work day in and day out. And when it comes to citizens, you can support all sorts of bad, ignorant, hateful speech. You can hold a placard and a sign promoting Hamas and their horrific attacks on Jews and on many people in the world when face little to no consequences. But there's a different formula that applies when you're an alien in America. Now, just prior to the September 11th attacks, the Supreme Court had a chance to clarify whether there were First Amendment implications for considering ideology or terrorist support in deportation proceedings. That was Reno versus AADC. And the Supreme Court decided to sidestep the doctrinal First Amendment issue. And it held that immigration law stripped courts of jurisdiction to even hear a selective prosecution claim in deportation. So after 9/11, material support laws, that is, providing material support to terrorists, were aggressively used to prosecute not only violent acts, but expressive activities linked to terrorism. There were many charities and activists who were charged for providing funds or even just speech that was seen as support for groups like Hamas or Hezbollah. A notable example was the University of South Florida. There's a professor, Sami Al-Areen. He was a Palestinian-born lawful resident. He was accused of raising money and organizing for Palestinian Islamic jihad. He argued that much of what he did was simply advocacy on Palestinian independence issues, but he was indicted for material support of terrorism, struck a plea deal eventually, and was later deported. But that line between what constitutes political advocacy and what is support for terrorism can blur, because what one side calls political activism, the other side calls support for terrorism. And it shouldn't be too much of a surprise to say that the president, sitting and directing executive policy, gets to make that choice. So a Woodrow Wilson is very different from a Lyndon B. Johnson, who's very different from a Donald J. Trump, who's very different from a George W. Bush. And you're going to see different flavors and feelings. And we've seen this throughout America's history as we've gone through different scares and concerns, sometimes legitimate, sometimes slightly exaggerated, about what outsiders are going to be doing for national cohesion, or for national security concern. Now, one area that shouldn't be overlooked is that while the First Amendment might not have too much to say about deportation standards, due process does. In fact, one of the first cases that touches on this, the Bridges v. Wixson case that I mentioned earlier, the Supreme Court said that meticulous care must be exercised in deportation proceedings because expulsion deprives a person of the right to stay and live and work in this land of freedom. So, due process. We need to have basic fairness involved in the proceedings, a reasonable notice of charges, the chance to rebut evidence, all the hallmarks of due process have to be present. And this is where much of the meat comes in for deportation challenges. Is there a sufficient showing of evidence that someone is linked and connected to a terrorist cause? Was proper notice given? Was a fair procedure in place? If so, then the courts and the immigration panels are typically going to defer to what the executive has to say about these standards and give little weight to corresponding constitutional concerns. Now, one area where basic fairness due process issues have sprung up is in the use of secret evidence by the government. I mentioned this in our TikTok video where secret evidence about national security concerns were put on the record and the opposing counsel had no access to them. I'm not a fan of using that. I think there are times when there are significant national security concerns, and I think that our country, our government is good enough to be able to and strong enough to put that on, make a showing to the American people, build faith in the process, and still be able to deport people who have problematic ties and connections to terrorism or operate in other areas of regulation and be able to show people. That only builds trust. So where we've seen some issues in deportation proceedings is this use of secret evidence where people don't have a chance to be able to rebut it, to be able to see it. And then we see some of these turned around. There was a Palestinian academic in Florida, Mazen Al-Jamir, who faced this. And the judges eventually released him on it, and he found that the evidence, at least the public evidence that everyone could see, was insufficient, and that secret evidence was procedurally unfair. What's a more recent case that deals with the tension between free speech and national security concerns? Well, that's Holder versus Humanitarian Law Project. That's because after 9/11, Congress passed laws prohibiting nonprofits and individuals from providing material support to terrorist organizations. Now, this reached even further than aliens. It went to actual citizens. But once again, that veil of national security was raised, and that's a very high-level concern, a compelling justification for the government. And indeed, the Supreme Court found that in that case, that limiting material support to terrorist organizations was justified by the government's interest in combating terrorism. Now, this brings us all back to Khalil. Khalil is alleged that his presence was contrary to national and foreign policy interests. President Trump had provided 2 executive orders on this issue, one combating anti-Semitism and another prioritizing deportation of individuals who are dangerous to America's national security interests. It also included some broader language about threatened American values, something to this effect. That part probably went a little too far, but the president certainly is acting well within his national security purview to make determinations about dangerous individuals and to be able to prioritize their deportation. Now, we have existing federal regulations and statutory provisions post 9/11 that actually empower the president to do this. So using an executive order to piggyback off of that certainly is well within the role of the executive to do. So the Khalil case presents something we've seen before, and that's the question of, does his activism at Columbia University provide a means for the government to expel him, to remove him from the country? Now, as we move through the case law, both World War I, World War II, the McCarthy era, post 9/11, courts have routinely held the same thing. And essentially, the analogy goes like this. When you're in America and you're a foreign-born citizen and you're still an alien, not a American citizen. You're here as a guest. It is a privilege to be in the United States. And so the courts doctrinally distinguish First Amendment issues from deportation and national security interests. Government can't come in and punish an alien for having participated in a pro-Hamas protest, but when looking at security determinations over on this side, they can say, you have no actual right to be here. You're our guest. It's a privilege. And we're going to show you the door now. Now, I've lived in foreign countries before. I've lived in Germany for over a year and done some academic work over there. I found many peculiar policies there, and I did not once protest against some of their socialist policies or destroy anything or the like. I was a guest on foreign soil. I kept those opinions to myself in a peaceful way. So the working analogy that I think that we see is if you're a guest in someone else's home, you better be polite or you're going to be shown the door. First Amendment case law from the early 19-teens going into World War II and subsequent eras routinely defers to the executive on this. If you don't like that sort of deference, then I suggest we make a change for that in America and at least allow government to have to put on a better showing as to why this is necessary. If you're on the left, I think you traditionally probably enjoy deference because all sorts of government programs get upheld routinely in court because of this application of this test. And if we have less of it, I think we have a more honest debate in the courts about which programs are actually appropriate and which ones serve genuine constitutional needs. But for now, deference is the game, and we're going to see that continue to be true in cases involving national security. So we think overall, historically, First Amendment-wise, constitutionally-wise, there's very little basis, I think, here for Khalil to make a claim that he cannot be removed from the country. And that's contrary to a lot of the shouting and rhetoric that we hear. We see pronounced First Amendment protest about this issue. People even breaking into Trump-owned properties and conducting themselves in all sorts of ways. It's a very emotionally charged issue. But the actual law, the actual tradition, the actual history, when you get down to it, very much goes against Khalil. His only real claim here that I can see is a due process attack, that the government moved too quickly and didn't provide a fair process to be able to challenge this. Now, I haven't seen the evidence in the case. Cases are won or lost based on evidentiary showings, so there's an angle there too. But for now, I think he's in a rather weak position to say, I was a visitor to this country. Yes, I obtained my resident alien status, but I engaged in some pretty nasty rhetoric, and I supported enemies of the United States. And now to claim surprise that you're being shown the door and asked to leave seems rather weak. Now, I thought it would be interesting. And I wanted to just say, look, there's such resounding support in American case law. What does this look like internationally? If we took someone like Khalil and we dropped him down in Japan or Canada or France, what would the result be? Maybe the United States is an outlier, because the United States is an outlier in several fields of law. For example, birthright citizenship is an outlier issue that's very rarely found anywhere else in the world. But let's see how it plays out as to if you were a foreigner in another country protesting, what would the result be? Does it look like America has taken some fundamentally unfair and weird stance? Or does it seem like it's the norm? So let's look at Japan. Japan's post-war constitution, like America's, safeguards freedom of speech. And it states that all of the people shall be respected for their fundamental human rights. All the people has been interpreted by Japanese courts to mean foreigners for many rights. But the Japanese government actually imposes strict limits on political activities by non-citizens. And the Japanese Supreme Court had a landmark case in 1978 involving McLean. Mr. McLean was an American activist. He participated in anti-Vietnam War protests, and when he sought to extend his residence, the authorities refused, challenged his decision as a violation of free speech. But the Japanese Supreme Court said that he had a freedom to express his opinions, but ultimately ruled the government could lawfully expel a foreigner for political activity. The case established that in Japan, immigration control and immigration determinations trump any free speech concerns for aliens. Now, Japan has seen other elements on this as well. There is an American military base in southern Japan, in Okinawa. My father served there for a time. And there's regular protests that go on there because of the American presence. And Japanese courts have done a similar sort of approach as American courts have. If you're a Japanese resident and you're picketing or protesting the presence of the American base, that's usually lawful and protected. And if you're an outside agitator of sorts, if you're an alien in the country, that's going to be seen as a reason to deport you or to not extend your residency status in the country. It's, again, you're a guest in Japan, it's a privilege to be there, and if you push too hard or agitate too much, the powers that be will remove you. So, Japanese process lines up pretty neatly with the American process. What about Canada? Canada has somewhat strong protection for free expression under its Charter of Rights and Freedoms, which applies to supposedly everyone on Canadian soil, not just citizens. So foreign nationals theoretically enjoy the same freedom of speech and assembly and association as Canadians. And it's not uncommon to see non-Canadians involved in protests. You can think about some of the famous environmental and climate activism protests that have gone on in Canada, where a variety of international actors are present. Now, under Canada's Immigration and Refugee Protection Act, a foreign national can be deemed inadmissible and also deportable for security reasons. And that means advocating for terrorism or providing support to terrorist organizations. Canada has a history of using, quote, security certificates to detain and deport non-citizen activists who are suspected of being aligned with terrorism. In the early 2000s, several Muslim foreign nationals were held without trial on secret evidence under security certificates, and the Canadian Supreme Court struck down process of that as, guess what, a violation of their due process standards that led to some reforms. But the Canadian government still has authority to remove non-citizens on security grounds for speech that would be fully protected if it were uttered by a Canadian citizen. So when we come down to Canada, we see a pretty similar standard as to what's going on in America, and quite similar to Japan. Let's take a look at France. France is the most restrictive of our batch of examples. They're a slightly more nationalistic country, and they're fairly sensitive on issues of perceived terrorism or communal tension, a sort of a national cohesion that needs to exist. France has a tradition of public order, and authorities are pretty quick to ban speech or assembly that threatens national values or security. And in the wake of the Hamas-Palestinian attack on Israel in October of 2023, France was one of the first countries to impose a blanket ban on pro-Palestinian demonstrations, claiming they risked igniting anti-Semitism or causing public disorder. France even went further. They had a crackdown on prosecuting individuals who expressed sympathy for Hamas or other terrorist-designated groups. Foreign nationals were made a priority in those investigations. They were explicitly targeted. France's immigration law allows the expulsion of non-citizens for any activity that threatens public order or state security. Now, public order is a pretty broad standard. And within their executive, that gives them a great degree of leeway and freedom to decide what that is. In fact, the Interior Minister in France said, as to pro-Hamas individuals who are aliens, we will not let them stay on French soil if they justify or support any terrorist act. you do a little deeper dive into France, and you see that they regularly use expulsion for foreign religious figures or activists who are in their country. In 2022, France deported a famous imam and a Moroccan-born cleric who had lived in France for decades, simply on the basis of he was inciting hate and discrimination in his sermons. He hadn't been criminally convicted. He had been under surveillance apparently for years in France without any charges, but they decided that the remarks and sermons he were given were anti-Semitic and, quote, anti-woman, and that posed a threat to not French national security, but fundamental French values. The French Supreme Court had a chance to be able to analyze this, and it said that protecting the public from his anti-woman, anti-Semitic speech outweighed his individual rights as a longtime resident. France has expelled countless imams and students or tourists, anyone linked to extreme speech. So the legal standard is ordre public. I don't speak French, so please excuse the murdering of that phrase. If a foreigner's behavior is deemed a serious threat to public order, they can be removed in a rather expedited fashion. So there, in France, due process concerns even lower, because expedited means just that. Very little emphasis on evidence or a fair trial, but getting you out of the country. Now, it's important to think about some of the differences with France. Of course, France does not have as robust of protection for free speech as America does. It punishes speech about some speech about the Holocaust, hate speech, apologies for terrorism, the list goes on and on. It has large swaths of categories of speech that are unprotected. So in summary, France leans heavily towards security and public order considerations and against free speech. So when we analyze the three countries weighed against the United States, we see that Canada and Japan line up pretty squarely with the American tradition, and France goes even further. So within just a random sample of civilized countries in the world, we see that America's approach to removing lawful resident aliens who connect to dangerous, controversial, terrorist-linked speech is not an outlier. It's very much the norm. I think we've done a decent job at taking a contentious issue because there's certainly some sympathy to be had for an individual who has a wife that's pregnant and is suddenly going to be removed from a country. There's also sympathy to be had for making sure that America's safe from Hamas, a group that rapes, murders, and acts barbarically against individuals that oppose it. And in such an instance, it's not a case of some First Amendment quandary or deep First Amendment question. The United States government has enjoyed the authority to deport lawful resident aliens for any linkage to dangerous terrorist-linked speech for some time. So it shouldn't be any surprise now that that's occurring. The protests that are bubbling up and popping up seem to be related to something else. I think there's probably an emotional reaction to a variety of the current administration's policies that is maybe fueling and causing people not to look at this issue as neutrally or as objectively as they should. I think the analogy that works best is what I led with at the beginning. When we go to a foreign country, we're a guest in that land, and there's certain norms of behavior that you get away with when you own a home versus being a guest in a home. I'm not going to leave dirty dishes and fart and burp and act in obnoxious ways when I'm staying with someone. And when my behavior hits a certain level, I'm going to be asked to be shown the door, and I'm going to be out on the curb. The same thing happens with nations, not just America, Japan, Canada, France. When folks who are visiting there as a privilege start to agitate and start to get close to a dangerous line connecting with terrorist organizations or adverse powers, they're going to be shown the door. I don't think we should expect any different result here, and I don't think this is as great a constitutional controversy as what a lot of the emotional rhetoric is behind it. So stay tuned. Next week, we're going to jump into yet more controversies that are bubbling up. I'm going to try to divide this channel between doing some deep dives on perennial, evergreen issues, and then on some of the hot topic, hot button issues of the day. Stay tuned next week. We'll see you then.